Oh, okay. So, Peter, should I start? It's
I'll,
fine.
I'll introduce you.
Yes, please go
So,
ahead.
so welcome to the Hellenic Law Society MCLE event, Law of the Sea Developments in Greece. Our speaker is Dimitrios Dimitrakos, a longtime member of the society. Um, Dimitri is a lawyer both here and in Athens, I believe, in Greece. And he has the unique distinction of having a master's and a PhD in the law of the sea. And he got that about a year ago, right, Dimitri?
Yeah, the JSD. Yes, I
Yeah,
finished it in December 23, technically
and
speaking. So,
he's also spoken to us on the topic once before. It's a great topic. And without further, Dimitri, the floor is yours.
thank you. Just one clarification. I'm not currently active in the Greek bar, but I do practice Greek law and law of the sea, of course. Anyway, thank you, Peter. Thank you all. It's nice to see those that I already know from the society. It's nice to meet the new persons here. This is as Peter said, my LL.M is in public international law, law of the sea being one field of that. My doctoral I just finished a year ago. It's in international law of the sea and water law, basically the law of the sea convention. So without further ado, I think I'm going to jump into our first slide, essentially outlining the structure of the presentation. I would like to start by giving some general information on the law of the sea, what it is not. Then I'm going to make some brief references to the background of the Greco-Turkish relations in the Aegean Sea specifically. In my view, this is a subject that never gets old or boring. My previous presentation, as Peter said, was about, I think, Peter, it was in 2020, I believe, if not a bit later. And back then, I had touched on some maritime boundary delimitation agreements that had just been concluded, the one between Turkey and Libya, and the other two between Greece and Italy, and Greece and Egypt on the maritime zones. What's new, relatively not very fresh, but since the last presentation, Greece did expand its territorial sea in the Ionian Sea to 12 miles. And by the way, whenever I refer to miles in this presentation, I mean nautical miles. So unless I say something different, just assume that miles mean nautical miles. I'm also going to be touching on the current state of affairs and some anticipated developments. And hopefully, I'm planning on leaving maybe 10, 15 minutes for in the end by 5:45 or so for discussion and any questions. So, what is not the law of the sea? So, I've seen some confusion about the meaning of the term, especially here in the United States. In international law parlance, law of the sea is not the same as maritime law or admiralty law. Of course, both deal with the sea, but law of the sea basically reflects the international law that has to do with interstate relations at sea. It is codified in what we call UNCLOS, the United Nations Convention on the Law of the Sea of 1982. It is also reflected in other treaties and international instruments that further implement UNCLOS's goals. The convention, UNCLOS, is largely a codification of customary international law. It does reflect customary international law, which basically means that not only is it considered to be binding on its state parties, but also non-state parties. So, distinct from law of the sea, maritime law, when again we see it from the angle of international law, maritime law essentially regulates private affairs at sea. It's not interstate law, it's private law. For example, contract law at sea, labor law at sea, or even torts, personal injury at sea. It is essentially private law at sea. So law of the sea is a field, a subcategory of public interstate, that is national law. It regulates interstate relations at sea. There is, of course, an overlap between law of the sea and maritime law to the extent that international marine environmental protection is concerned. Many treaties, for example, the Marine Pollution Convention, MARPOL as it's called, that impose obligation on private actors like ship operators, essentially implement state obligations prescribed under UNCLOS to regulate marine pollution and protect the marine environment. Interestingly, in the US, the law of the sea is often referred to as ocean law, international maritime law, or international law of the sea. It is okay, and it's as correct to just call it law of the sea. There's no need to preface it by international because it is international by default. So very quickly, we can find law of the sea, of course, in the convention, in UNCLOS, the law of the sea convention, which, as we said, codified pre-existing law, both conventional and customary, though. UNCLOS negotiated over a span of 10 years almost, from 73 to 82. It is a global, almost universal treaty in that it numbers about 170 state parties, including the EU, or parties, including the EU. It establishes a general framework for the regulation of the seas. Sometimes you may find that authors refer to it as the Constitution of the Seas. It's not technically a constitution, but to the extent that it sets a general framework for the regulation of the oceans, it has been referred to as such even by the UN Secretary General. It is broken down to 17 parts. It contains about a total of 320 articles plus 9 annexes. About half of its articles regulate maritime zone issues. In large part, it is binding on non-party states. You will see in the convention many references to many articles will start by saying all states or states, for example, Article 192, states have the obligation to protect and preserve the marine environment. It doesn't say state parties. It says all states. This has been meant to imply its customary law status as well, in addition to its conventional binding force. The US participated in the negotiations, those 10-year-long negotiations, but unfortunately did not sign or ratify the convention. That being said, it accepts that most, if not all, parts of UNCLOS reflect customary international law. Interestingly, if you go to the website of the National Oceanic and Atmospheric Administration, NOAA, which is a federal agency, you will see that it recognizes UNCLOS as reflecting customary law, which would mean that the US would be bound by it, even though it's not a state party. The law of the sea is also found in other treaties that implement UNCLOS, as well as in case law by the International Court of Justice, the International Tribunal of the Law of the Sea, and not only in cases of dispute resolution, but also in the case of what we call advisory opinions. These are non-contested proceedings whereby the ICJ, the International Court of Justice, or ITLOS in Germany, will issue an opinion upon request by certain qualified organizations or entities on a legal issue. So recently, about a year ago, in May of 24, ITLOS in Germany issued its first advisory opinion on the obligation of states on regarding climate change. A big part of that advisory opinion discussed and analyzed obligations under UNCLOS. Mind you, the advisory opinions are not binding, but of course, as you might be able to appreciate, they're highly authoritative. I think they may be roughly equated domestic, when it comes to domestic law, to maybe Supreme Court opinions or maybe restatements of the law, something similar, the rough equivalent on the domestic plane. So this is not an up-to-date map, but that's the best I could find from Wikipedia. That's a map that reflects the ratification status of UNCLOS. The light blue, which is most of the countries, and the dark blue, which refers to the European Union, are countries that are parties to UNCLOS, that is, the convention has entered into force for them. Of course, the big absentee here is the United States. You see Alaska and, of course, the continental US, and some other countries. I mean, Turkey is another non-signatory. Israel is not a non-signatory, but Russia was up to a few years ago. But you can see why it's called, it is an almost universal global treaty. So I'm not going to go through all the maritime zones that are regulated under UNCLOS, but take a look for a few seconds. These are the main zones that are outlined, all the zones actually, maritime zones that every coastal state is entitled to, plus the high seas in the area. So we're going to talk about territorial sea, the continental shelf, and the exclusive economic zone, as well as a bit about the high seas. Um, so let me move on. Just to show you, that's a reflection of the maritime zones from above. This image shows, this is the coast. Let's say, imagine we have a drone, and if we could see in the water, so you see that the territorial sea or waters, as it's called, can reach a maximum breadth from the coastline, from the baselines, as it's called, up to 12 nautical miles. There's a contiguous zone, which is kind of an auxiliary zone for an additional 12 miles. The exclusive economic zone, which can go all the way up to out to 200 nautical miles, and the continental shelf, which can go all the way up to 200 miles, and in some exceptions, in some cases, out to 350 miles or a bit further out. So this is another representation, reflection of like a vertical section of what the zones would look if visible in real life. So you see the sea, how it submerges under the water, under the sea. This is where the coastline is, and you measure out 12 miles for the territorial sea and 200 miles for the exclusive economic zone and for the continental shelf. And the outer or the outer continental shelf can go, as we said, beyond the 200 nautical mile limit. High seas refers to the water column that starts being measured from either from the end of the exclusive economic zone where one exists, or if none exists, from the outer end of the territorial sea. The area refers to the seabed and subsoil beyond of the oceans, but outside the outer limits of the continental shelf. So the high seas are international waters, what we also refer to as international waters. So some basic points about the territorial sea. It is essentially equated to land territory for purposes of sovereignty, meaning that in its own territorial sea, up to 12 miles out, a coastal state enjoys full sovereignty, subject of course to what's called the innocent passage of foreign vessels. Full sovereignty also means that the coastal state has complete and full legislative and enforcement jurisdiction in all matters in its own territorial sea. The basis here is the concept that the territorial sea is equated to land. So think of it as a liquid soil, a liquid continuation of land into the sea. Flag state law will usually apply on board a foreign vessel, even inside the territorial sea of a coastal state. There are some exceptions where coastal state law might apply, but generally just remember that flag state prevails, even inside in a territorial sea of another coastal state. We said I can go all the way up to 12 miles from the baseline. So now what I would like to clarify about the term continental shelf is that in UNCLOS, in the law of the sea context, it is a legal term, not to be confused with the geological continental shelf. The physical continental shelf is the actual soil going under the sea and all the way out to the ocean. It can go sometimes up to 1,200 miles, maybe sometimes it's shorter, sometimes it goes even deeper. And then it stops and there's a sudden slope into the abyss, what we call the abyssal plains. So the continental shelf is distinguished between the legal one that we care about in the context of UNCLOS and the geological one. The two do not coincide. It's very rare that two will coincide. So whenever we talk about the limitation of the continental shelf, we are always we mean the legal continental shelf. This is the definition. It says that Article 76 of UNCLOS basically saying that it comprises the seabed and the subsoil outside of the territorial sea of submarine areas and can go all the way out to 200 nautical miles. Even if the physical self, the continental margin, the end of the geological self, does not extend all the way out to that distance. The continental shelf exists, legally speaking, ipso facto and ab initio from the start, meaning that the state does not need to proclaim it or do anything to claim any sovereign rights in its own continental shelf. So these are basically the rights that a coastal state can assert and has in its own continental shelf. Basically, these are referred to as sovereign rights for the purpose of exploring the shelf and exploiting its natural resources. Natural resources mean living and non-living, mostly non-living, which is essentially whatever is found on the ground, on the bed, and in the subsoil, petroleum, natural gas, stuff like that. But also living organisms that essentially are in constant contact with the seabed. This is the distinction between living organisms subject to the continental shelf regime, as opposed to fisheries and other living organisms that are subject to the EEZ, the exclusive economic zone regime. Let's see, let me move on. I don't want to get too technical. However, I think some of these points are important. The exclusive economic zone essentially entails the continental shelf, but it also includes the water column right above it. And again, we said all the way out to 200 miles, nautical miles. In this sense, natural resource can be either non-living, petroleum, any minerals found on the bed or into the subsoil, as well as fisheries or any other living resources. Another technical difference is that the EEZ must be proclaimed, which can be done through a domestic law or some other act. It doesn't need to be proclaimed internationally necessarily. Greece, interestingly, has not proclaimed its own EEZ on a general basis. And in a parenthesis, I'm saying right, but also an obligation maybe. There is some discussion about whether, of course, each state has a right to proclaim its own EEZ, but there's some discussion as to whether this is also an obligation from a marine environmental protection point of view. Each state also has rights, but also obligations in its own EEZ to protect the marine environment. So Greece, by avoiding to proclaim an EEZ, might be seen as trying to evade its own marine environmental protection obligations under the convention. Let's see. In the EEZ, the coastal state has sovereign rights for the purpose of exploring and exploiting, plus conserving and managing the natural resources, living or non-living, of the waters and of the subsoil and seabed. You will see, by the way, I don't want you to confuse sovereign rights with sovereignty. Sovereignty, we only refer to sovereignty in the context of territorial sea, and we refer to sovereign rights in the context of continental shelf and EEZ. Sovereign rights essentially are exclusive rights in the sense that the coastal state may exclude other states from exploring and exploiting its own EEZ or continental shelf. But they do not equate to sovereignty. They're just full exclusive rights for specific economic reasons: exploration, exploitation, conservation, management of resources, and protection of the environment. And of course, you see a distinction here that says it also has jurisdiction as to the establishment and use of artificial islands, installations, and structures that would be, for example, oil platforms in the EEZ. Marine scientific research, the protection and preservation of the marine environment. These are jurisdictions that a coastal state has in addition to its own sovereign rights in its own EEZ. There are some other rights and obligations provided for in other parts of the convention for the EEZ. I'm not going to say much about the islands. The only thing I want you to remember is that, generally speaking, islands are entitled to a territorial sea, to a continental shelf, and to their own EEZ, like regular continental territory. Even islets are entitled to that, and even rocks are entitled to a territorial sea. There is one limitation when it comes to rocks, which are formations above the water at high tide that are basically smaller than islets. That's a rough definition if you want. Rocks, while always having a claim, being entitled to a territorial sea, they only are entitled to a continental shelf or an EZ only if they can sustain economic life. In practice, what this means that even a rock, which is let's say 2 acres in surface, if it has enough grass to sustain a herd of sheep, that's considered to be sufficient to sustain economic life. Therefore, those rocks would be thought of being entitled to an easy and continental shelf, in addition, of course, to a territorial sea. Just, I want to make a distinction between the concept of delimitation of maritime boundaries or maritime zones and delineation. Delimitation refers to finding where the midline is when we have overlapping um, maritime zones of opposite or adjacent coastal states. So to the extent that there's an overlap, this overlapping area must be somehow delimited. This is where the concept of delimitation, line of delimitation, comes into play. Delineation refers, it can have a couple of meanings. It doesn't mean delimitation, but it usually refers to the outer boundaries of each of these maritime zones where there is no overlap. So let's say 200 miles of exclusive economic zone, there is enough room in the Pacific Ocean for the US to do that. The outer lines of the exclusive economic zone will have to be delineated on the map with coordinates. That's not delimitation, that's delineation. So how do we delimit overlapping territorial seas? Let's say in Greece and Turkey, they have opposite coasts or the islands with opposing territorial seas, where the basic rule is that whatever the two states with overlapping territorial seas can agree will prevail. In the absence of agreement, the norm is the median line. The median line is the line again that splits the overlapped zones, the overlapping surface of the zones into half. Roughly speaking, it's not exactly that, but it's called median line. So agreement or else median line, that's the rule for delimiting overlapping territorial seas. When it comes to delimiting overlapping EEZs, and that's the same rule as with continental shelves, again, the rule is agreement which must be um, uh, leading to an equitable solution. In the absence of agreement, let's say that the coastal states cannot agree to where the delimitation should be, the rule, if the case is taken to court, is equity. The result of the delimitation must be equitable, and by that, as we will see later in the next couple of slides, equity does not always mean 50-50. It's not the same as the median line. In some cases, the equity might dictate adjustment of the equity of the median line either towards one coast or the other. So this is what I would like you to keep from that. Oh, delimitation overlapping continental shelves is exactly the same rule as with EEZ. Basically, agreement that achieves an equitable solution. If not, states must resort to the mandatory dispute settlement mechanism. Let's see. Just a few points on UNCLOS's dispute settlement mechanism. That's under Part 15 of the Convention. So UNCLOS has a mandatory dispute resolution mechanism which gives states, parties, many options. But upon joining, upon ratifying, upon expressing consent to be bound by the Convention, every state must declare which one of the options for dispute resolution it chooses. One option could be resorting to the International Court of Justice. The other could be resorting to the International Tribunal for the Law of the Sea. In case they don't declare an option, arbitration, or in case the two litigants, let's say, have chosen different options, the default method is arbitration. That being said, the parties can choose any other form of dispute settlement of their choice. They're not bound, but they just have to, they just have to try to peacefully reach a reasonable and equitable solution in most cases of these disputes. I'm not gonna get stuck here. That's the legal test that the ICJ uses when it hears in a joint case delimitation cases for continental shelf or EEZ disputes. Essentially, the court, in order to try to delimit such disputes, it will start with the equidistance as a provisional line, and then it will, at stage 2, it will say, are there any relevant circumstances that might justify adjustment of the median line, of the equidistance line? If so, the court will adjust the line here or there towards one coast or the other coast. And as a final stage, it will do it will take a final look to see if its result meets what's called a disproportionality check, which means that any solution that the court would give should not represent a gross disproportion between the duration of the respective coastlines and the ratio between the relevant maritime areas. That's so technical, it's fine, but I just want to share it with you. So, just remember, as we said earlier, equity does not always or necessarily mean equality. I'm going to stay here. Let me say a few things about the Greco-Turkish dispute, historical background. Well, in 76, Turkey conducted its first seismic survey on the Greek continental shelf in the Aegean. The two countries back then reached the brink of war. Seismic, whenever you hear seismic survey in the ocean, it means they're looking for petroleum, basically, at least back then. Now it could be other resources. Greece instituted proceedings in the same year, took Turkey to the ICJ, to the International Court of Justice, but the case was dismissed for lack of jurisdiction in 1978. One weird thing, looking at it from a domestic law point of view, is that in order for a country, a sovereign state, to be taken to the International Court, it has to agree. It has to have expressed its consent to be sued, let's say, in some form or another. So Turkey was found to not have expressed such consent, hence the case was dismissed because the court found it didn't have jurisdiction to hear the dispute. In the 90s, since the 90s and later, Turkey has traditionally pursued a more aggressive stance in the Aegean and the Eastern Mediterranean as a whole. Greece has had and still has a 6 nautical mile territorial sea in the Aegean, and I'm going to show you some maps so I can make it more interesting. These points. Turkey also has a 6 nautical mile territorial sea in the Aegean, but has extended to 12 nautical miles in the Black Sea and the Eastern Mediterranean. It threatens Greece that if Greece extends its Aegean Sea territorial sea to 12 miles, this would be cause of war. This is the notorious casus belli, cause for war in Latin. One of Turkey's claims is that the continental shelf in the Aegean should be split 50-50, which essentially would mean that Greece would waive its sovereign power to extend to 12 miles and sovereign rights in its continental shelf and EEZ in the Aegean. So I want to also mention that if Greece extends, and I'll show you on the map how that would be, but if Greece extends its territorial sea to 12 miles in the Aegean, the legal issue of delimitation of the continental shelf essentially practically becomes moot in large part.
Thank you.
So, interestingly, Turkey and Greece participate in the 9-year negotiations of the convention. Greece, of course, reserved its right to extend to 12 miles whenever it decides to do so. Turkey is not a state party to UNCLOS nor to the EU. I can hear some noise in the background. I don't know if you could mute your microphone.
Yeah, because I just have to clip it off or find it in the actual
So again, no EEZ has been proclaimed yet officially and generally by Greece or even Turkey in the Aegean. So with 6 nautical miles territorial sea in the Aegean, a bit more than half of the Aegean is high seas. With a 12-mile territorial sea, about 80% of the Aegean will come under Greece's sovereignty. And I'll show you essentially how this will look on the map. So this is the current state of affairs. The blue line represents Greece's current territorial sea of 6 miles in the Aegean. And the orange or red, however it appears to you, is Turkey's 6 miles territorial sea zone in the Aegean. I mean, here where there's not enough space, there is kind of a median line, not officially delimited. So this is the 6 mile situation. The white here represents high seas, in other words, international waters. This is a comparison of the 6 versus 12-mile territorial sea in the Aegean. So you see that if Greece expands, the high seas will significantly be reduced to about 20-25% of the Aegean in the Aegean Sea. So this thicker band of blue represents a 12-mile territorial sea in the Aegean. And this thicker band of orange represents the Turkish territories in the Aegean, if that's ever taken to that point. As of now, we still have 6 miles throughout the entirety of the Aegean Sea, both on the side of Greece and on the side of Turkey. This is another map that shows, let me try to zoom in if I can. The bright blue is a 6-mile zone, territorial sea zone. The lighter blue represents what Greece's territorial sea would go out to if it expanded to 12 miles to territorial sea.
Dr. P,
Yes.
how are you, buddy? Good. Good. Nice to see you.
Hello?
Kalispera.
People on mute. Please.
Push.
You know, one of the
Hello?
meters, but
Hello?
stopped at 16. What's that? At 16.
Thank you, guys. Could you guys
just
please
made
mute? There's a lot of
6.
background noise. Hello? Yes. Oh, thank you. So this map essentially represents Turkey's claims. Basically, the red line shows Turkey's vision about the Aegean. It essentially ignores the fact that the islands have a continental shelf and that Greece could extend to 12 miles. The black line here represents the median line between the eastern coast of the eastern Aegean islands of Greece and the Turkish coastline. So this is where the median line takes us. And this is essentially, I'll show it to you. Oh, hold on just a second. Where are we here? So this is another map. So that would be Turkish claim. It wants the Aegean Sea 50-50, ignoring the Greek islands' rights. And that would be, I mean, it doesn't show very clearly here, but you can see the red line where my arrow goes, which reflects the median line, essentially, between the opposite coasts of the Greek islands in the eastern Aegean and the Turkish coastline. So this is a map that shows the maritime, the continental shelf and the EEZ in the Eastern Mediterranean. The delimitation lines have been drawn with the assumption that the median line is the starting point, is the line of choice. So you see this is what Greece's EEZ would look like. Turkey's EEZ, Cyprus's, Egypt's, Libya's, and of course Italy's. This is another map that shows Greek exclusive economic zone, which would include the islands. And again, it's based on the principle of equidistance. This is a map that shows some other European Union member states' EEZs. You see Ireland here, France, northwestern Spain, Portugal. Of course, in the Aegean, in the Mediterranean, the Eastern Mediterranean, Cyprus has declared an EEZ, has proclaimed an EEZ. Greece hasn't officially and generally, and I'll tell you what I mean by generally in a few slides. This is another view. You see that Cyprus has proclaimed its EEZ, Greece hasn't. It has signed in 2020, as we said earlier, two delimitation agreements between Italy and the other with Egypt. However, these indirectly, you could say that within the scope of these two delimitation agreements, Greece has indirectly proclaimed an EEZ, but again, there is no general proclamation that Greece is entitled to EEZ on a broad basis, unfortunately. This is just a representation of the EEZs in the world. Just a few points here. Since the 90s, Turkey started disputing not only the Greek sovereign rights to continental shelf, but also Greek sovereignty on that means ownership of Greek islands, certain Greek islands. There were three major crises that almost led to the brink of war. The one it was in 76, 78, the other was in 87, and the other 96. You see, there used to be like a pattern of almost every 10 years. The 96 crisis actually had just been discharged from the military a few months before, and I remember the tension was such that I was about to be recalled. I in my class, other fellow citizens in my class. So in 19, Turkey signed a memorandum of understanding delimiting its alleged zones with Libya, and I'm saying alleged because I'll show you on the map that agreement encroaches on the Greek continental shelf. It assumes that Crete has no continental shelf whatsoever, or any of the islands of the southeast Mediterranean for that matter, like Rhodes, Carpathos, or Kassos. In 2020, Turkey started again seismic surveys on the Greek continental shelf in the Eastern Mediterranean. These surveys have been discontinued. They almost brought Greece and Turkey to the brink of war again. In 2020, again, Greece signed, as we said, its maritime delimitation agreement with Egypt and Italy. Interestingly, as you will see in the last bullet, in August of 2020, Greece announced that it plans to extend its territorial sea in the Ionian Sea to 12 miles. That was probably and understandably in reaction to Turkey's delimitation agreement with Libya of 2019. And lo and behold, a year later, actually a few months later, in early 2021, Greece actually signed extending territorial sea in the Ionian Sea to 12 miles. But before going there, I just want to show you, this is the situation in 2020. There was a Greek survey ship doing seismic exploration in what Greece considered to be its continental shelf. And of course, the Greek Navy went there, the Turkish Navy positioned itself around there to protect its own ship. That was a Turkish commercial ship, of course. The last minute war was averted. So that was in 2020. This is just the first, the main page of the Turco-Libyan Memorandum of Understanding, the delimitation agreement between the two countries of 2019. This is a map that was attached to that Turco-Libyan Memorandum of Understanding that's not very visible, but I'm going to zoom in. I want to show you. So you see here, this line here is the coast of Africa. Crete is here. This is the this is all the Eastern Mediterranean. Cyprus, the Turkish coastline, Rhodes, Crete. So Turkey and Libya delimited their overlapping in their opinion, of course, overlapping continental shelf and exclusive economic zone by drawing this line, the line A to B. So basically, this disregards the fact that Crete is entitled to its own continental shelf or exclusive economic zone. or the other islands, the island of Rhodes, of Carpathos, and Kassos. I'll show you another slide, another map. Okay, see. So this is the line that I showed you earlier, line A to B, essentially establishing the limit, the delimitation line between Turkey and Libya. You see how it discards all the islands in the Eastern Mediterranean, in the Eastern Aegean, Southeastern Aegean, as well as, of course, the island of Crete. This is Turkey's vision of the Aegean Sea. It's called Blue Homeland. Again, you see how it doesn't factor in any entitlements to the ocean bed or the sea that Greece would be entitled under the law of the Sea Convention. Okay, I'm not going to stay on that. The Greek-Italian agreement, the delimitation agreement of 2020, essentially it established a median line. I'll show you what it looks like on the map. This is largely a median line between Greece and Italy. This line essentially copy-pasted almost verbatim the provisions of an earlier 1977 agreement between Greece and Italy on the continental shelf. The main difference is that now the 2020 agreement extended the agreement to the exclusive economic zone. Back then in 1977, the concept of exclusive economic zone was still being negotiated during the UNCLOS negotiations. UNCLOS had not been concluded yet. So there was no such official concept as the EZ at the time. The Greek-Egyptian agreement, I'll show it to you on the map, is a partial delimitation agreement, partial in this is the line here. This is the island of Crete. This is the coastline of Egypt. And you see that delimitation line between the EZ of Greece and the EZ of Egypt. This is another look at that, at the EEZ delimitation line. I want you to take a look at the green line here. This is what was agreed in 2020 between Greece and Egypt. The continuation, this white continuation shows the rest of the line, of the delimitation line between Greece and Egypt, which was not included, which was not agreed on in 2020. It's still pending. The reason was that because of the complications with Turkey at the time, and still, Greece didn't want to go beyond this partial delimitation that's represented with this green line here. This is essentially the line that was agreed on in 2020 again. There remains to be delimited this area here. And this was again based on the equidistance, the median line principle. By the way, the main difference between median and equidistance, actually it's the same concept, but we use the term median line when we overlap, when we delimit overlapping areas of opposite coasts, whereas equidistance line is used when we delimit overlapping zones, not of opposite coastal states, but of adjacent. So, but essentially it's the same principle. The median line is equidistant. So let me move on because let's see what time is it. Okay. This again, what the delimitation between Greece and Egypt looks like. This is the delimitation between Turkey and Libya. You see how it would encroach. It encroaches on the Greek continental shelf and EEZ for that matter. There are some developments. We said the law that extended the Ionian Sea, territorial sea of Greece was passed in 2021. Again, that pertains only to the Ionian Sea. That's geographical scope. It does not extend to 12 miles in any other sea of within Greece's sovereignty. There was some critique as to whether it was legally okay to expand partially the territorial sea, or whether even politically or diplomatically that would weaken Greece's claim or momentum to expand its Aegean Sea continental shelf at a later point in time. Legally speaking, there is no prohibition in the law of the sea. You can coastal state can expand in stages if it wants to. It's not prohibited, therefore it's allowed. What I think is more important is that that law that expanded to 12 miles in the Ionian Sea caused some distrust to the Greek public opinion because they start thinking, oh, what's is something cooking about the continental shelf in the Aegean? There have been some thoughts or rumors, unconfirmed, we don't know, but there's still rumors that it's possible that within Greece's plans is that it may delimit in the Aegean in partial stages and not necessarily up to 12 miles. It could do it in up to 8 miles for some islands, or 9 or 10 or 11 miles. That said, Greece consistently reserved its right to expand to 12 miles. Anyway, this law was important. It was the first time that Greece expanded to 12 miles since the ever in history. So, interestingly, in February 2023, Greece was referred by the European Union to the Court of Justice of the European Union for failing to submit maritime special plans as required by EU law. The reason that's important is because maritime special plans, which is area-based tools that say what activities are allowed in what maritime zones of each coastal state, presuppose the existence of territorial sea, exclusive economic zone, continental shelf, and the limitation thereof. Greece had not submitted such plans to the European Union. Still, it hasn't. In the meantime, a few months later, in 23, there was a political instrument signed between Turkey and Greece in Athens, the Athens Declaration of Friendship, or Proclamation of Friendship, if you will. The dispute process by which Greece had been referred to the Court of Justice of the European Union in 23 came to an end about 10 days ago. Greece was found by the Court of Justice of the European Union to be in non-compliance with its European maritime special planning law obligations. I want to show you very quickly here, if I can. This is one of the websites of the European Union. Has dedicated to marine special planning of its member states. You see, it has maps based on the equidistance principle for all its seas. For Greece, for example, let me move this down. This is what Europe believes Greece's maritime zone should look like. If you scroll in, actually, let me see. You may be able to see that some thin lines here that assume a 12-mile territorial sea, not only the Ionian, but also in the Aegean. And then expanded up to, delimited, of course, because there's not enough room, but an expanded EZ.
Dimitrios, I don't think we can see that map.
Okay, it's fine. I'm gonna close this anyway. Here it is. Can you see this? Can you see this map?
We can see it now.
Yes, we can see.
Okay, so this is drawn from a European Union's website on maritime special planning. It assumes, while this is not adjudicative in any respect, it shows that, and it's based on other European Union member states' practice that have exercised the right to a median line delimitation, even when it comes to continental shelf and EEZ. So you see that Europe says, okay, this is what I think your EEZ should look like. And actually, this is what I think you're entitled to under the law of the sea in terms of territorial sea. The 12-mile territorial sea and the expanded EEZ. Of course, Greece, as we said, hasn't proclaimed an EEZ yet, at least not directly. There is these two indirect proclamations within the context of the Greco-Italian and the Greco-Egyptian delimitation agreements. Now, another interesting development that was actually very recent, recent in terms of latest development. I don't know if you've heard about the Great Sea Interconnector Cable Project. This is an electrical cable, a submarine cable supposedly will connect electrically Israel, Cyprus, and Greece, and of course by expansion the European Union. It's going to be a submarine cable. The concept itself is about 15 years old. It has not materialized yet. It's a €1 billion project, subsidized about half of it, about 650 7 million is subsidized by the European Union. There are some other third parties involved, both states and non-state actors. France, of course, there's a French company called Nexans that's the manufacturer of the cable. There's some Italian ships that, on behalf of Nexans, do exploratory surveys on the seabed, trying to see where the best course would be to lay the submarine cable. So in July of this last summer, an Italian ship, let me try here. An Italian ship was doing surveys, exploring the seabed of Greece within the Greek territorial sea of 6 miles outside the islands of Kassos and Karpathos. This is Rhodes here, just to give some perspective. I'll show you. So the blue line here represents the 6-mile territorial sea, waters. So the moment the left was an Italian ship, they left the territorial sea to go from this point to that point, even for a few hours. The Turkish Navy came and actually demanded that the ship request permission to do any work in the high seas. Remember, because in the Aegean we only have 6 miles of territorial sea and not in proclaimed EEZ, anything outside the 6 miles is still considered high seas, international waters. This doesn't mean that this is not Greek continental shelf, because remember, continental shelf refers only to the seabed and subsoil and is not contingent upon any proclamation. It exists automatically, ipso facto and ab initio, as we said. That said, that incident though shows how delicate and sensitive the situation still is. We're talking about late July in 24 now, and even since then there have been some other incidents about the same project. So the Italian ship left. I'll show you where Kassos is, so you can get a perspective. You see it's northeastern of Crete. That would be Greek continental shelf. Ship and the cable, the submarine cable, is supposed to leave from Israel, go to Cyprus, then first to Kassos, and then to Irakli on Crete, and then to the rest of Greece and Europe. So let me show you. In February, just a month and a half earlier, again, service ships were obstructed. Italian service ships that were serving the seabed on behalf of Nexans, the French company, the manufacturer of the cable, were obstructed by Turkish Navy in about the same area. So about a week ago, I heard on the news that Greece decided to freeze temporarily both the payments to the French cable manufacturer, Nexans, and also to further seize any further research or surveys. And again, the 2 Italian ships left the sea area east of Crete. They went back to Italy. Allegedly, the Greek media, the Greek government said that the ships had completed their work inside the Greek territorial waters or territorial sea. That's why they left, and they will come back at a later time to continue their work outside of the 6-mile zone. However, the issue is also now posed by the new Greek Minister of Energy before the EU. A few days ago, this was brought up before the European Council of Ministers of Energy. Essentially, Greece is asking the European Union to assist in the case. And diplomatically, it's also possible that, as we said, we have France being involved because the manufacturing company is French. It is involved because the ships are Italian. After this incident, the US is kind of being approached by Greece directly or through Israel indirectly for purpose of trying to offer some kind of security throughout the remaining life of this project. Where things will go, we don't know, but you can imagine how sensitive things are at the time. The problem with Greece is that now with the new US administration, it's afraid Greece is concerned that if it resorts to the US for assistance or support or some kind of other intervention, the US is now going to favor Turkey's claim more so than the previous US administration would be willing to do. So Greece is trying to kind of figure out its next steps. It's not a very easy position to be in. But this is the situation, unfortunately. So this is what the submarine cable would be. This is what the course is thought to be. So if that project ever materializes, the cable would leave Israel, go to Cyprus, then to Kassos, Heraklion, Crete, all the way to Athena, to Athens, and then from there, they would use the existing infrastructure to supply even Europe with electricity. So I think I'm about to finish because I want to leave some room for questions. Um, UNCLOS on submarine cables essentially says that every country has the freedom to lay submarine cables and pipelines on the continental shelf, not on the territorial sea of another coastal state, but on the continental shelf. There are some limitations there. I'm not going to get into details. The coastal state just has the right to consent to the course that the submarine cable should be taking. That's obviously to protect, environment, against any environmental complications or to protect against damage to other pre-existing cables in the area, especially in cramped areas. You have to be careful where you lay submarine cables. It could cause damage. This still, I'm not going to get into the articles of UNCLOS. The delineation of the course for the laying of such pipelines is subject to consent. The pipelines require consent. The submarines, not specifically, not explicitly. Submarine cables do not require the consent of the coastal state. However, if there's a interpretation that goes that if a submarine cable follows a route that could jeopardize the security of a pipeline and that could cause an environmental catastrophe, then the coastal state could indirectly be thought to have the right to determine the delineation even of a submarine cable. Let me see. That's okay. On the high seas, also, all states are entitled to lay submarine cables and pipelines. Again, high seas can exist above the international waters, can exist above continental shelf if the coastal state like Greece has not proclaimed it EEZ. So high seas again start where the territorial sea, or if one exists, the EEZ end. Some developments. Oh, that's interesting. Again, about a week ago, on the news, I saw that Libya had announced a new bid round for exploitation of energy resources in its own maritime zone southwest of Crete. The blocks that are out for bidding, I'll show you on the map. That's not a very good map, but that's the best I could find. This is the Libyan coast with darker blue. If you can see, let me zoom in. You can see Crete, the continental Greek mainland here in the Peloponnese. So this area, so you see that the orange blocks are the blocks that Libya just announced out for bidding. It seems that Libya seems to be maybe indirectly, politically, for some other expedient reason, it avoided opening up for bidding any areas in the maritime zone, its own EEZ, that it had delimited back in 2019 with Turkey. This could be a very useful tool in Greece's hands. It might be far-reached legally because Libya can anytime say, "Oh, I'm announcing bids for this area too." But the fact that now at this point it kind of seems to respect Greek continental shelf rights, despite the 2019 MOU that it has with Turkey, is a potentially positive step for Greece. Let me see. And with that, thank you. And I'm at your disposal for any questions.
Dimitri, if I may jump in
Yes.
first. Thank you for this excellent talk and the excellent presentation. I had maybe a couple of more questions about the maritime cable. So even if a cable passes through the exclusive economic zone of a country, then this country has essentially only the option principally to consent to it, unless there are any technical reasons why I cannot. But there's no really any grounds to prohibit such a project.
No, actually, not even grounds to prohibit. You cannot actually the consent of the coastal state, on whose continental shelf the submarine cable is going to be put on, does not even have a say. Is not cannot even, does not even have the right to withdraw consent or even to consent. Only indirectly, as I said, the consent right. Let me go back to show. I want to show you here, Article 79. It talks about laying of submarine cables and pipelines on the continental shelf of a coastal state. All states are entitled to lay submarine cables and pipelines. Pipelines essentially, they carry gas, natural gas, stuff like petroleum, stuff like that. Cables are used for communications, marine scientific research. They're just wires. So only the delineation of a pipeline, not explicit of a cable, is subject to the consent of the coastal state concerned. And the reason for this distinction between pipelines and cables is that obviously pipelines are more environmentally sensitive. If there's a damage, it could lead to a environmental catastrophe. So no, a state cannot prohibit, to your question, cannot prohibit the laying of submarine cables of its own continental shelf. Neither can it require another state to ask for its permission or consent.
Yeah, so basically, Turkey had no grounds whatsoever to intervene in this search,
Of course
right?
not. But let's assume hypothetically that a Greek ship was wanted to pass to lay a submarine cable on the actual continental shelf of Turkey. Let's say Turkey has some continental shelf in the Eastern Mediterranean, right? It doesn't require Turkey's consent as long as it's not. Now, in practice, what happens? States notify each other, but sometimes for several reasons. For the reasons of usually a NAVTEX is issued before, making sure that there's not going to be any danger to navigation. A NAVTEX, which is an official communication, naval communication, and notifies other states saying, "Oh, on this date or on that time, there's going to be a military exercise there, or going to be a ship operating laying submarine cables. Be careful not to cause a collision," for example. But no, there's no right for a state to prohibit from its own continental shelf, of course, let alone another state's continental shelf. There's no such right. This is essentially, the freedom to lay submarine cables and pipelines, one of the freedoms of the high seas, which is transported, extends to the continental shelf. So because it's traditionally considered freedom of the high seas, the rights that the coastal state has to intervene are very limited. Of course, again, when it comes to concerns of environmental nature, the coastal state may say, "I do not consent to this delineation." But this is usually expressly, this right applies to pipelines. Indirectly, there are some authors that say that it could apply to cables, provided that the submarine cables are so close to existing pipelines that it could damage them, thereby potentially causing an environmental incident. In this case, the coastal state in question could have the right. That's a theory, at least. But explicitly, no, there's no such requirement.
Dimitri, I did not see the Gulf of America on any of your maps. But I did see the blue zone. And my other question in the same vein is this about the South China Sea and China erecting these fake islands. At least that's what they tell us. I assume there's some truth to that. China creates these fake islands out in the middle of the South China Sea. Have you studied that or thought about that at all?
Yeah, that's a good question. Of course, I don't know there was a big case actually that was even in my dissertation. I referred to it many times. It was an environmental case essentially It dates back to, China's activities in the South China Sea are not new. They they date back years, decades into the past. And actually, there was an arbitration between the Philippines and the South China Sea that, the Philippines actually initiated arbitral proceedings against China on several grounds, including marine environmental damage, essentially stating that China did not fulfill its environmental obligations under the convention, under UNCLOS. The arbitration was complete in 2017. China didn't appear officially, so it was, but it did submit some documents there to explain its position, but it basically didn't appear. Hence, the arbitral award was issued in default of China. Anyway, China was found to be in violation of many provisions of the convention. Its activities included destruction of coral reef in the area, fisheries, dumping toxic waste. So I think it's one of the the South China Sea continues to be one of the most challenging situations there, areas in the world, as I see it. I don't think that China will stop anytime soon, withdraw from its activities there. There's a lot of resources for the South China Sea to be disregarded by China. I don't think so. And by the way, China totally disregarded the arbitral award against it. It just continued. So I don't know if this answers your question, but I don't think anything positive will come out of what the situation has been so far and how we have been able to evaluate it. So might is right, essentially. This is the law of the sea as implemented in that region of the world.
Well, if there's no further questions, let's give Dimitri another round of appreciation. And we thank you immensely. This is a great talk. And our next talk is on AI and the law by Professor Lucky Jackson, I believe is his name. Judge Canellis knows him from the judge circles.